Great. For those that are joining us online, my name is Elizabeth Gibson, and I am one of the co-chair leads of our Operations Peer Network. I'm also joined by Amanda Cote, who is my other co-chair, and we are excited to introduce Stephanie Ramia Sandifer, a partner with Clement Rivers Law Practice out of Charleston, South Carolina. She practices primarily with the firm's Employment and Labor Law Practice Group and assists both public and private and nonprofit employers in employment matters, including day-to-day employment issues, federal and state litigation, as well as proceedings before administrative agencies such as the EEOC, South Carolina Human Affairs Commission, and the NLRB. Stephanie also has experience in representing clients in corporate dispute matters, asset purchase deals, personal injury, premises liability, and professional liability matters. Prior to joining Clement Rivers, she served as a staff attorney for the South Carolina Supreme Court. And in law school, Stephanie was the research editor of the Southeastern Environmental Law Journal and served as a representative for the Student Bar Association. She also worked for the South Carolina Senate Judiciary Committee and a Columbia law firm. Before law school, she worked for a large international business and litigation law firm in Washington, D.C. I've worked extensively with Stephanie in the past, and I'm so excited. Please join me in welcoming Stephanie to speak about the new overtime regulations. And I'm going to let you take it away.
Good morning. Thank you, Elizabeth. I did not realize that you had my very long introduction or bio taking me back to pre-law school, so I appreciate that introduction. And I'm happy to be here with y'all today. And I know this is a very important topic for you all as nonprofits. As Elizabeth said, she and I have worked together for a long time, and this has definitely come up with us and her organization. And so I'm happy to be able to kind of share some insights, as to how you all can implement, things to address this new salary rule or test and this significant increase. So, we'll go ahead and get started. And I think all of you all know, obviously, what the FLSA is, but this act establishes the federal minimum wage and obviously the overtime standards, record keeping requirements such as pay records and that sort of thing that employers are required to keep, as well as standards for employing youth. The FLSA applies to employers and employees in the private sector as well as the government sector at the federal, state, and local level. I know sometimes, or I understand that there is often a question now, especially now in light of these salary increases, as to whether nonprofits are covered at all. And I think that is a serious question and something to consider. But to briefly kind of go over that, that coverage issue, you can have enterprise coverage where the employer organization is the entity that's that's subject to the FLSA, where that entity is involved in interstate commerce and has at least, quote, $500,000 in sales annually. In addition, what is more often than not relied on by the Department of Labor, which is a federal agency that enforces the FLSA, is individual coverage. And that applies to individual employees, meaning that, say, your entity does not meet the requirements for enterprise coverage, that you still may employ individuals that are covered under the FLSA and the protections provided therewith. And that's oftentimes that it can include even the ordering of supplies from out of state, and dealing with that type of interstate commerce or regularly making phone calls to people in other states. Those are often factors that are considered and that would support individual coverage under the FLSA. And but today, I know what our focus is, but I wanted to go over a few of the common issues for employers involving the FLSA, satisfying the minimum wage and overtime requirements, independent contractors versus employee classification, which is also an issue with the IRS. So it's not just the FLSA that might impact that classification, as well as inaccurate records or failure to keep records, which you are required to keep records for at least 3 years on hand. And oftentimes it's advisable to keep records for 7 years, more so. That's probably the path of least resistance on that issue. And then another major issue, and today we're focusing on the exempt status in light of the new rule imposed by the DOL concerning the salary threshold, is where employers assume an employee is exempt because they are salaried, even though they do not meet the duties test, which we'll talk more about. In other words, there's always confusions over the terms hourly versus salary, and these terms are not wholly determinative of exempt status under the FLSA. As we'll discuss more, that means that simply because you designate or call someone salaried does not mean that that person is exempt from overtime requirements under the FLSA. There are additional tests and elements that have to be met in order for an employee to be exempt. So while that's the focus for today, that's and it can lead to unknowingly violations of exempt status and issues such as discipline, unpaid leave, or withholding or deducting from a paycheck when an employee is out of office, that sort of thing. And then what I see a lot on the employer management side is obviously dealing with restaurants and hospitality. So hopefully you all are not in that business, but if you are in the business and have anything related to tipped employees, that is always a struggle for employers keeping up because those regulations are ever changing. I think one I recall changed 5 times in like 5 years. It just sometimes depends on the administration that's in place and how the DOL sets those regulations and rules. So, without further ado, we'll get into the topic that we're here to talk about today, and starting with exempt versus non-exempt. So you can have someone that's hourly non-exempt, which means the employees are paid on an hourly basis, and they must be paid at least a minimum wage of $7.25 an hour. And these employees are eligible for overtime pay for any hours over 40 that they work in a work week. And that rate is 1.5 times their regular hourly rate. So that's pretty simple. If you pay someone $10 an hour, any hours, including half an hours, or, if they just work a half hour over 40, so 40 hours, 40.5 hours, that half hour has to be calculated at 1.5 times their $10 hourly rate. And then you can also have a salaried non-exempt employee, meaning the person is paid on a salaried basis, i.e. you don't outright say that they're paid $10 an hour. Rather, you calculate that out to say, and I'm not a math person, that's why I went to law school, but say you pay them $40,000 a year, then and that's what the salary agreed to. However, you break it down because it's 40 hours a week to an hourly rate, and it can be done that way. And oftentimes these are employees that are not paid to reach the minimum salary thresholds and or do not meet the duties test available for any exemption, because you have to hit both the salary test and the duties test, meaning that their primary responsibilities meet the different or sometimes a combo of the different exemptions available under the FLSA. And then lastly, the other term is salaried exempt. So, and these are employees who are paid on a salary basis, which means they're paid the same amount each week or each pay period, no matter how many hours they work. And it's equal to at least the minimum threshold, which is the issue, the main thing as the most recent change today. And they also meet the duties test of one of the exemptions. So this is where, the language you should really use exempt versus non-exempt when you're trying to classify an employee for purposes of overtime and whether they're subject to overtime protections under the FLSA. You can still use that term hourly, but you want to always include exempt or non-exempt. So that's often a thing that I see employers getting tripped up on, again, because they just say they call that person salaried, but their job really isn't doesn't meet the duties test, so they need to be paying overtime. That's definitely one thing to keep in mind, and try to I would strongly encourage putting that practice in place of using the terms exempt versus non-exempt. And then so the big thing that we're here to talk about, obviously, is the salary thresholds. And so to put it in front of y'all, the next big one, because as I understand it and have worked with several clients, including nonprofits, the increase that happened on July 1 wasn't necessarily a huge impact. Or more likely than not, that wasn't as significant. It's really this increase that's coming up on January 1 to $1,128 per week, which is equivalent to $58,656 per year. In less than 3 months, and that's going to happen in less than 3 months. And that salary threshold for exempt employees, don't quote me on my math, but I think I got it right, is obviously going to jump about $15,000, which is over a 30% increase. That's huge. And then in less than a year total from the start of this, when the rule became final, that's almost a 65% increase from the prior threshold of 35,568 to 58,656. And that's obviously over 20,000, a $20,000 pay increase in less than a year. So that is significant. And while the DOL was challenged on their ability to to set the salary, at least one U.S. Court of Appeals, the Fifth Circuit, has said that DOL does have the authority. Now, there might be further fights on how much, and how big of a stretch they have, authority to increase the salary amount. And I think the biggest question is going to be on the after 2027, and what they have the ability to do to set it that far in the future. Because you all are obviously a nonprofit organizations, but it's still a business. Obviously, you're not there, you're not trying to make a profit. However, you still have to have enough money to maintain your operations. And so if there's an increase every year, that's not only going to hurt private sector businesses that are for profit, but you all as well. And so I think that's something that to keep an eye on, any future litigation challenging the extent of their rule making authority when it comes to the salary amounts. And so, again, because this rule is just in place, litigation is probably, 1, 2, 3 or more years out to really when there's significant decisions. So the question really is what do we do to meet that increase, or evaluate whether that's even possible for you all as nonprofits? And I think that is significantly where an internal kind of audit with the help of legal counsel can come into play, and you look at the duties test. Here is, it's EAP is the shortened version, but these are the 3 that are often looked to: executive, administrative, and professional. And some courts will allow you to, or I've seen it where you can kind of combine executive and administrative duties to meet an exemption. But often more than that, you're kind of trying to plunk into one bucket of these 3 choices. So executive means managing a department or an entire enterprise and directing at least 2 employees regularly. Obviously, this person would have the authority to hire, fire, or say it's a department manager, their recommendation is given weight, right? It's not just lip service, what their preference is. So And then administrative is someone that primarily performs office or non-manual work related to the management or operations of the organization. And their job must require them to exercise discretion and independent judgment over important matters. Meaning that they can't just be, a secretary is someone that's administrative, right? Quote unquote. However, they really don't necessarily exercise significant significant amounts of independent judgment, but rather are just following directives given to them by their supervisors. And then, of course, the other one is professional, where the work duties require advanced knowledge of science or learning customarily acquired by prolonged specialized intellectual instruction and study, etc. And this is where doctors, lawyers, teachers, engineers, computer analysts, etc., typically fall under this professional category for exemption. So that's what you want to start with, is whether, even if you could meet the salary test, or requirements in your budget, does the job actually meet the duties test for one of these exemptions under the FLSA? And then of course, there's also the highly compensated employees, which is another exemption. And I'm sure though that this, given that the amounts of the increases in the HCE category, it's probably unlikely that you all would have someone categorized as this in this exemption or in this category, but I did want to show it to you all to make sure we covered, the 4 primary areas of duties that are looked at. And so what do you need when you evaluate whether the job actually meets the duties test, and what needs to be in a job description that allows the employer to classify the employee as exempt under the FLSA? Initially, I want you to keep in mind that a job description is not determinative of the duties test or exempt status. This is particularly true if the employee does more than what's in their job description, goes either above and beyond or is asked to do more than what's in their job description. So to get their actual responsibilities is key. I mean, you have to look at and analyze, what does the employee actually do in his or her role? And that is very important to include in the job description, as well as in assessing exempt status. So it would definitely be in an organization's best interest to evaluate each employee's more job description as well as their actual responsibilities. And I see that you see my note to myself, so I apologize for that on this slide. But when looking at to get their actual responsibilities, for them to provide feedback on the current, would be to allow the employee to provide feedback on the current job description, and note that you are looking to update it based on what the employee actually does in a workday. I don't know that you necessarily have to give them all the details about the evaluation, why you're looking at it, but simply, I'm sure that there are several job descriptions that probably could use some updating in the organization, because that's often overlooked unless it's a new job that's created. And so then you have to create a job description to put out, for marketing for that open position, et cetera. The other way, is to just simply ask them to provide a list of what they do every day. What are the tasks that you do? Give me your day-to-day or a weekly kind of rundown. And the duties test that we just talked about can be helpful in assessing and making this assessment, because courts look at this to determine whether the employer meets the guidelines for the exemption. And they often look and consider strongly, although again, not determinative, the job descriptions that are in place when applying the duties test, and whether the employee acts as an executive, administrative, or professional, and whether he or she may meet that exempt category. So that's, the duties test is definitely helpful to consider when putting together job descriptions. In addition, job descriptions, you want to include only the essential functions. You don't, while the employee, when you ask them to give them their day-to-day, they might get really tedious and give really specific things. You don't necessarily, it's not necessarily needed to put those exact things. That might be more of a, here's a, that you use in training, you know what I mean? Like as more explanation of more general job responsibilities and duties. But I would definitely take a look at your current job descriptions and when assessing whether or not you all as a particular position in your organization is going to be able to meet not only the salary threshold, but then the duties test, and to evaluate whether that position is going to be subject to overtime requirements. So I wanted to go over some examples that who would and would not meet the duties test. So example one, I'm gonna read it out, but I'm sure you all can read it too. But it's a manager of a nonprofit's thrift or furniture store who's paid on a salary basis and works over 60 hours per week. However, she's never been paid overtime because she's been classified by the employer as an executive. She has worked as a cashier, in her managerial duties. She also cleans and stocks shelves. She also completes inventory, fills out sales paperwork, creates employee schedules, handles customer complaints, and is responsible for hiring, training, evaluating, and firing employees. She set compensation for she also sets compensation for hourly employees and communicates to management when she feels that an employee deserves a raise or other discipline of the like. So the employer argues in that case that she satisfies the executive exemption. Is the employer correct? I'd like you all to raise your hand, or if you believe the employer is correct, your little virtual hands, or write in the chat if you think the answer is yes, that the employer is correct. Okay, I think it's hard for me to see because my screen is set, but I'll
Tell you most of the hands are raising for a yes, and
okay.
even in the chat, they're saying
Okay.
yes.
Thank you.
You're welcome.
Well, you all are right. So I wouldn't be worried about you guys then on that question. Because yes, the manager meets the executive exemption. While she performs some non-managerial tasks, her primary duties appear to be supervising and managing other employees. Her role at the store is critical to the store's operations and to the operations of the nonprofit. So, and in addition, a big thing is that she has significant discretion over employees, right? That authority to hire and fire, and or it is known that she heard perceptions and or opinions about employee and their performance is received and taken into consideration by upper level management. So good job on that one. Sometimes I'm always nervous, so that more often than not, I mean, that was probably a softball, so we'll see on the next one. But the next one is you have a quality control official whose duties at the nonprofit's produce market includes examining produce and other farmers market type products, as well as marketing the produce market and its happenings and completing paperwork. All marketing strategies and or campaigns have to be approved by the nonprofit's executive leadership. And the employer in this instance has classified this employee as under the administrative exemption. Is the employer correct? Again, raise your hand if you think yes, or write in the chat if you think yes. And Elizabeth, I'll rely on you again to let me know when everyone's responded.
I haven't seen anything in the chat, but nobody, oh, we got 2 hands raised for yes, but the rest have not raised their hand. So I think we're torn.
Well, those that didn't raise their hands would be right. The quality control official does not satisfy the duties test for an administrative role. The official based on the description, has no supervisory responsibility. He or she does not develop policies or strategies. In other words, his work or her work was not directly related to the management or business operations, and he or she did not exercise significant or independent judgment or discretion over important matters. Meaning, they had no supervisory responsibility. And, that's often a key thing. So, but again, one fact could change that, right? One essential duty of an employee oftentimes can be looked at, and that if that essential duty is non-managerial and or just typical manual labor. So you want to be very careful when making that analysis. And oftentimes there are maybe not for the most quirkiest positions, but there's oftentimes significant guidance from court opinions, that have decided and evaluated whether a particular job or an employee's role meets the duties test under a particular exemption. So I did want to talk about some additional scenarios and or questions that may arise like in this analysis that you all should, if you haven't started, should be undergoing, before January 1 to make that determination of whether, someone is going to, you're going to keep them at exempt, or whether you're just going to, put them in, classify them as non-exempt, and then they would be subject to receive overtime for any hours worked over 40. So one of the questions I think that often arises in this context is, for anyone who doesn't make the minimum of 58,000, can I just move them to an hourly employee, or can I just increase their salary to the new minimum and make them exempt? Sure, you can definitely do either of those things. But the law, behind it and behind the decision should be explained to the employee, because they could view any jump negatively. As well, they actually have to meet the duties test. So it's not just the salary amount. I know that's what this question focuses on, but they definitely have to, meet the duties test in addition to the salary if you're going to try and make them exempt. And going back to the whole viewing negatively, as I'm sure you all are aware, as I've talked with clients about this before, is salaried employees who are moved to hourly see this as less prestigious, right? That term salaried is just kind of has always had this notion or context that you're in a prestigious position, and which they are. Everyone's important at every organization. But so sometimes moving them to quote hourly might have a negative impact on them or their, personal perception. And that's again where the terms exempt and non-exempt are important, because that's really what we're talking about here, right? Is exempt versus non-exempt. So as you all know, for hourly employees, they have to keep strict track of their time working, which is also oftentimes a negative. So that person that might have been salaried exempt prior to this new salary threshold rule, maybe had to track their hours for some grants and projects, or just generally speaking, but they didn't have to clock in and clock out every day, right? They didn't have to show or clock out for lunch or that sort of thing and clock back in. But so just keep that in mind, that you want to try and maybe spin it as a positive and say, we're just, looking at this. And again, that's where the terms exempt versus non-exempt may be helpful. And then hourly's employees that are moved to salaried, even if being paid more, that could be seen as, without evaluating the duty side of thing, that could definitely be viewed by a court as the employer's attempt to just eliminate overtime pay, so just be mindful of that. And then another obviously major thing to consider before reclassification is whether that, from exempt to non-exempt, is whether that employee typically works over 40 hours per week. So in other words, the KISS method is do the math. try and get a ballpark picture of if they're regularly working 50 to 60 hours, you want to make sure that you don't, if you move them to hourly, that it's not going to be even more than, say, this increased salary that's coming up. So because they will receive 1.5 times the hourly rate for overtime. So you would take their salary, their current salary, divide it by, the amount of, weeks in a year, et cetera, and break it down to the hours, to a per hour rate, and then kind of do a ballpark assessment of 1.5 times that rate, if that employee works 50 to 60 hours each week. You just want, so you want to do that math, and look at that. And this analysis should also be carefully documented, both, this as well as kind of any documentation as to the duties test. Obviously, if you seek legal advice on any of this part, that would be attorney-client privilege communication, any advice letter, so that wouldn't be subject to discovery. But as an organization, you want to generally keep, good records of this decision-making process, minus your attorney's advice being quoted in anything that you may, a memo that you may save to the file. The other thing to do is you also want to consider this, the South Carolina Payment of Wages Act, on notification with regard to pay. Now, notice under that act is only required, 7 days notice is required for decreases in pay, but you may also want to consider providing notice of this reclassification and or any increase in pay to the employee in writing, versus just a verbal, hey, we're making this decision, and that's because you just want to, again, it's more of, that's a record that you can show that you've kept records and or, that this decision was made, but also just to show that the employee was given notice of the terms and conditions that may have changed as to their employment and or compensation. The next kind of scenario or question that I think is more likely would be pretty common is, what should you do if you have two employees in the same job, but one makes more than 58,000 and one makes less? Do you need to make them both hourly now? And or, and that's oftentimes you might have that difference in salary based on their tenure with the, organization. But the answer to that is no. Salary is not dictated by job title. And then there are multiple factors that go into compensation, such as, like I mentioned, previous experience or tenure with the company, et cetera. So the exempt versus non-exempt status is based, as I've kind of tried to hone in on, is based both on salary and the job duties. So if the minimum salary threshold is not met, but the EAP duties are, the employee is still non-exempt. Now, that doesn't mean you can't categorize that person who does meet the salary threshold and the duties, because it's the same job, right? Meet one of the executive, administrative, or professional exemptions. That person is exempt. So it doesn't matter, it is based on an individual basis. So just keep that in mind, when you're looking at that, because I know, again, you all may have different employees in the same jobs, but again, their tenure has allowed them to earn more over the years. And so there may be a difference with someone, say, that's been with the organization 15 years and someone that's been with the organization only, 3 to 5 years. So again, just remember, assess it on both the salary test and the job duties test. So what should you do if you have a pay band for a specific job that spans on both ends of the spectrum, right? Below the salary threshold and then above. Would all positions in that band now be moved to hourly, i.e. exempt? That should be in the question as well. But the answer is no. Again, the non-exempt employees are not all don't all have to be hourly. And it's really that term non-exempt versus exempt. So you can have a non-exempt employee paid on a salary basis as long as the minimum wage is met upon calculating their corresponding hourly rate. So if kept on salary, and they're non-exempt, the time still must be kept in a strict manner, meaning they still have to, clock in clock in and clock out type thing. And in order for you all to be able, or the organization to know when overtime is owed, any hours that are worked over 40. But you don't, just because you have a pay band that might span the, above and, below, the salary threshold, doesn't mean that that dictates whether that job is exempt or non-exempt. Or whether you need to classify them as hourly or salary. It's really just, you just have to look at the duties test, in order, that's the main crux, because if you have someone that comes in at 10 years experience and you do want to pay them 59,000, then they, again, if the duties for their job position meets one of the exemptions, they've obviously met this, upcoming increase, in salary. And then you have, so that they would be exempt under the FLSA, and you would not have to pay them time and a half for any hours worked over 40. So that's an overview of, the new salary rule, and I'm happy to answer any questions.
We have a couple that have come through the
Sure.
chat, and so I will read off of them. So one was, do we need to include the exempt and non-exempt classification in job descriptions?
It's not necessarily required, but it's a good, it's good to include it, because then that's clear when the employee, signs a job description, because you should have them sign it so that they know that that's what their, main essential functions and responsibilities are. But it's not, like by statute, it's not required. But most employers, it's advisable for them to go ahead and include it, again, because that's a record of the decision made as to whether exempt or non-exempt. And oftentimes it might be included in your notice letter, notice of terms and conditions. That is also a consideration.
And then also from Kendall, she asks, is the salary threshold requirement, do we use it to determine exempt or non-exempt?
It's not solely determinative, as we've kind of gone over. You have to do the salary threshold as well as the duties test. So the duties test is really the key, because you could have someone that is paid 68,000, so above the salary threshold, but their duties don't meet an exemption. So that, therefore they would not be exempt simply because they have they're paid on a salaried basis. But they, again, they're not an executive, an administrative, or professional.
Great. Do executive directors have to have a job description as well?
It's advisable that they do, especially if you have, if there's ever any question, as to whether that executive director I'm assuming many of you are governed by boards, that whether the executive director is executing his or her, not just fiduciary responsibilities, but actual job, then yes, I would, you would want something on paper, to, hold them to, just like any other employee, simply because they're at the helm of your either small or very large ship, doesn't mean that they are, exempt from making sure that they complete their job, and work, towards the goals of the organization.
Is the minimum threshold salary calculated by the net or gross amount that an employee receives?
Is the minimum salary, say that one more time, sorry. I'm trying to find
I'm translating. Is the
Yeah.
minimum salary threshold, do we calculate it off of the net or the gross amount that the employee receives?
It would be the gross amount. I think it's, because that would just be, I think, too much, especially if they have deductions that they've chosen, you know what I mean, for health benefits or other things, or retirement. It would be, the gross amount.
The next question is, does the overtime requirement apply if we have a compensation time policy in place?
If we have,
Kendall, I'm looking, do you mean like comp time policy?
Yes, yes, we have a comp time policy, so if you work over a certain amount, then you're required to like comp that time within a certain window. So does the time and a half for non-exempt employees, is that required even if we have that in place?
yes, because comp time is really tricky for non-governmental entities. And really should be very limited, and because it's really only allowed, like straight up comp time policies, are really only allowed for government entities. So, and I would, out of an abundance of caution, always pay those non-exempt employees, overtime, because that's significant risk. I mean, if you get an overtime violation, not only is it the wages amount, which can be dictated by, obviously, if they have a high hourly salary or high salary, but then you get liquidated damages under the FLSA. So that's ×2. Plus attorney's fees are awarded typically under the FLSA. So, comp time policy should be really carefully looked at, I would advise, by your legal counsel, and make sure that it's, not, a true comp time policy that only government entities are allowed, but rather a flex time policy, that allows a little bit of flexibility within a work period, and really should only be more so geared towards, exempt employees, that are, program directors that have to go to town meetings, at night, or city planning meetings, or stuff on the, weekend things and et cetera. But I would definitely advise getting that looked at to make sure that you are not currently in violation, of the FLSA with that comp time policy.
Thank you. The next question is, do bonuses count towards salary threshold?
Sorry, I had that typed out because I saw that one, but no, bonuses are not considered part of an employee's salary. They are treated as additional income, but oftentimes they are, they should be, they're in addition to employees' regular wages, and so their regular rate of pay. And as I believe, the DOL deems those as extra, and then that they are, not, part of the salary. But these have to be discretionary bonuses, there is that distinction. There is there's a list, that the DOL has, provided that of what is exempt from, from the calculation of salary. And the bonuses typically have to be discretionary, meaning that the employer has the sole discretion, to decide, that bonus, and that's usually near the end of a period, corresponds. You see it a lot in, sales. I'm trying to think hypothetically of what you all may see it as a nonprofit. And then, the employer has, the discretion to determine the amount at that time, and whether to pay it, so not only the amount is, has to be, in the employer's sole discretion, but also whether you pay it or not, like i.e. a merit bonus or something like that. And then the third is whether the bonus payment is not made according to any type of prior contract or agreement or promise, causing the employee to expect such payments regularly, i.e. it's not in a handbook policy. Definitely don't do that, because that, even though handbooks should not be, we try to write them that they're not considered contracts. Oftentimes they're, still relied on as such. But, and I would say one example of what's not discretionary is where you have a like in the legal world, right? There's a written bonus policy for associates. And so if they hit their target hours, or, target things, they automatically get this bonus. The employer, we can take it away, but for the time being that it's promised, it's owed. So that's not really a discretionary bonus. That's really a production bonus, base bonus. And non-discretionary bonuses, such as the one I talked about, would not meet the statutory requirements of discretionary, and therefore are not excludable, from the salary, and therefore would be considered part of it. So look at your bonus, structures if that's something that is an issue, and in determining whether that can be included in salary, and maybe if it's a non-discretionary bonus and it can be considered part of the salary, the question then would be, does that get you to the salary threshold, for that particular employee? So lots of things to consider there. But again, it would depend on the type of bonus, discretionary versus non-discretionary.
Great. There's a question from Kendall.
Sorry, I feel like I've had all the questions today.
Don't worry, I have one for her
glad there are
too. We're not
questions.
finished.
Okay, good. Okay, so essentially the salary threshold is the base salary and not the salary package, correct? Unless it's a non-discretionary bonus structure.
Right. I mean, not knowing what you mean by salary package, yes,
So salary package includes like PTO days,
right. No, it's the base
holidays.
salary.
Okay.
Yeah, it's what they're paid every single pay period, no matter, how many hours they work.
Okay, great. And then would you advise, because just talking about bonuses, would you advise that bonuses not be specifically listed in an employee contract?
I mean, it depends on the situation, right? Like, is this employee exempt versus non-exempt? Are you really having an employee contract for a non-exempt employee, or what level? I mean, do you want to have a contract? Now, whether it's listed in a terms notice, which is not a contract, it's just a notice of compensation terms. You can put, it in there, maybe eligible for a discretionary bonus, or maybe eligible for a bonus if you just want to keep it vague, to decide whether you're going to have a discretionary versus non-discretionary bonus structure. But yeah, I mean, I think you got to look at first as a whole, what do you need, what's the goal of the employment contract, and or employment agreement, and versus having the employee be at will and now granted, you can write an employment agreement with an at will provision. That is
Yeah, we have that.
A new thing.
That's what we have.
It lays out, obviously, can be just on paper, not just job duties, but other fiduciary responsibilities. But I would not, unless it's like an automatic bonus, that they're guaranteed in compensation, then no, I would not include it as part of the employment agreement. But you can put it as, in their general offer letter, notice of terms, that they could, be eligible for a bonus. And then, but I wouldn't necessarily, unless it's a hard and fast rule, or implementation, I would not include an employment agreement. And I think that also protects the nonprofit as a whole to the extent that the money is not there, right? Like that,
right.
Something significantly happens to your budget, some type of outside issue that was not planned for comes up and takes away, you all have to reallocate or something like that. So I would, unless or it's guaranteed, I wouldn't put it in a contract.
Okay, because right now we list out the entire salary package, which includes the bonus, which is based on structure determined by the executive director. And we have the provision at the bottom of every employment agreement that says you're an at-will employee. and an at-will employer. So we have that as well.
Yeah, and you would also want to have that clearly in as a provision within the contract, not just at the bottom.
Okay, yeah.
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 But if you are describing it as discretionary by the executive director, then then that might be okay to include, but
Okay.
I would more than likely, just, avoid it altogether unless,
Okay.
you really feel that they negotiated in there or something like that.
Okay.
Because that can be set by policy, right?
Right.
Which
Right.
as everyone
And we
knows,
have that.
yeah, handbook policies can be
Yep.
changed at any time by the employer as long as there's notice given,
Yep.
so, but yes, I hope that is helpful.
Yes, very helpful. Thank you.
Great. So my question was, and how we pay an employee, the difference how you pay someone who is hourly non-exempt versus salary non-exempt.
Okay. Well, I mean, you would pay the salaried exempt employee, or sorry, salaried non-exempt, the same amount. Typically, that's what the definition of salary is, no matter what their hours meet. However, if they're, and hopefully it's just a standard 40-hour work week, right? That's their expectation. They're clocking in and out. Now, what happens when they go over 40 is that you have to calculate their salary, take their salary for, calculate it down to a work week, and then 40 hours divided by that, or divide that by 40 hours to get their hourly rate, and then you would use that to get the overtime rate for hours worked. So it's just more math in calculating their pay, but otherwise they're paid salary typically. Now, if you don't want to meet the true definition of salary, then you would say, hey, you're making $45,000 a year, which equates to blank per hours based on the, expected hours each week, right? So you do that on the front end. And so you can, while you telling them they're salaried, you can put them in your payroll system as hourly. And they would still see the paycheck, pay stub. Either way, they're required to keep time, right? I mean, if they're non-exempt employees. So, I think there's multiple ways you could handle it. It might be just what's easiest for the organization, and whether to do the math on the front end or just bank on them knowing, that they're going to hit 40 hours every week, and then you just pay them that same amount, and then obviously the overtime rate for anything over 40.
All right. The last question that I had that was posted was, would someone be willing to share their policy and structure? And I don't know if we have a common place that we would share that.
Well, this might be for me.
Yeah.
I wish that we could have like just a big old bank of policy documents that folks could just take and use and share and slap their logos on. However, we've been advised by legal counsel that organizational policy is a matter that is highly specific to each organization and needs to be tailored to those organizations, and some policy documents are also the intellectual property of said legal counsel. So there's some things that we can share, some things we can't share, some things that you would need to really make sure are specific to your organization anyway. So yes and no.
I appreciate that, Ben. So what I will say is that if you do need help writing your compensation policy or structure, the two pieces of advice I would give is either reach out to Stephanie because she can help you do that, or two, also reach out to Ben because he has, we have some consultant collaborative people who would be key to helping you set that up.
Absolutely.
All right, I don't see any more questions. So Stephanie, thank you so much for your time and on behalf of Together SC and especially on behalf of Amanda and me from as the ops co-chair leads, we really appreciate your time. And for those that are online, please see Stephanie's information. She's been a wealth of resource to me through many different issues. We worked together for quite a while now. So I appreciate you and all that you do, and I hope everybody has a great day.
Yes, thank you again for having me.
Thank you so much.